duty of all committee members to avoid conflicts of interest and appearances of conflicts of interest in performing the duties of this committee and the duties of the state bar. Any member of this committee who is aware of any conflicts, personal or otherwise, or appearances thereof, with respect to the matters before this committee should disclose those at this meeting. Any conflicts? All right, hearing none. We did send out, Brian did send out, and Suzanne did an agenda. And it's, and Brian, the title of your materials, confidentiality of public information, is kind of an oxymoron. And we'll get into that as we discuss the comments. But I think to begin this, we should recap the inquiry, how it started, and Suzanne, I'll do that quickly if that's all right with you.
That sounds great. Thank you.
Yeah, the initial subcommittee meeting involved an inquiry in Ray Kahn, and it was a narrow question. Bobby Kahn from Union County had submitted this issue about whether or not he could go on a podcast and talk about a case that was widely known and was brought in the Supreme Court. And he, in an abundance of caution, he asked his client if he could get her consent to do so. She declined and forbade him from going on a podcast and publicly discussing the case that he handled for her. And this is the case involving her apparently shooting a bird or middle finger at a law enforcement officer that was heard in the Supreme Court. The subcommittee, we did have a bare quorum. Amy Richardson, Bill Pittman, myself, and Suzanne met by Zoom or telephone. And we discussed at the beginning whether or not our inquiry should expand to looking at changing the rules 1.6 so as to allow lawyers to talk about public information or public record information, generally known information. We, however, quickly decided to focus on the narrow inquiry submitted by Bobby and tailor our answer to the narrow inquiry. We looked at other jurisdictions that have looked at this inquiry, and there were 4 other jurisdictions and an ABA opinion that came down with the opinion that any information obtained in the course of representation should not be disclosed or revealed. And so we answered that narrow question consistent with the ABA and the 4 other states. We did take off the table the issue of First Amendment inquiry because that's really not within the scope of the rules. That's a court question. And we, in our opinion, correctly decided the narrow question that Mr. Kahn submitted. And we were certainly expecting the tsunami of comments that we got. And we certainly did. I think in my 5 or 6 years on the ethics committee, this may be the most comments I've seen, except maybe that AVO committee, Brian, that I was on that went on forever. But
right.
So, but we got a tsunami of comments. So Brian or Suzanne or Amy or Bill, you guys want to add anything to that summary?
I think you nailed it.
I think you're fine.
So, yeah. So you know, I guess the next thing on the agenda is the discussion of the comments, and I read them all through yesterday, and they seem to fall into some pretty broad categories, and so they were universal in their rejection of the results of this opinion. And some of the comments were sophisticated enough to understand that a rule change was in order. Most of them seemed to think that we could change the opinion and interpretation of the Khan opinion to expand to allow generally known information and public record information. I disagree with that, with those opinions. And I guess the third big bucket was, you got to be kidding me, kind of responses that, so let's talk about the comments and whether or not we need to highlight some more than others. And I'll just throw the floor open to discussion.
Well, I can comment just quickly. I mean, I'm really glad we got all the comments, and in some ways they mirrored our discussion, which is, man, this is really frustrating. I think in particular for me, because I decided to read all of them. It's like, a good Google review on your work. But I think the comments in particular about the CLE limitations to me are in particularly very compelling, and I get it. I totally understand it. But I think I stand where you do that, not to get ahead, but to me, even the comments led me to the idea that I still think we're right under the reading of the rule, and everybody else, how they're interpreting it. But I hear them, I get it, and I agree, right? So that leads to where we go next, but just wanted to comment on that.
Yeah, Amy, I think Amy, you and Bill both said at our initial meeting that the information is the client's information. It's not the lawyer's information to put out in public. And so I agree. I think it's decided correctly under the present reading of Rule 1.6. But I do feel the pressure from the bar to change the rule and bring it in line with some of the other states that Suzanne has picked out for us to look at.
And Eben, I agree with that completely. I think it was the interpretation's correct one, and agree with you down the line on the comments, and we need to change the rule, and whatever way that turns out to be, it doesn't need to be some sea change. It just needs to be amended to reflect that it's really just talking about confidential information, not information that's publicly known.
So
go ahead, Jack.
Yeah, no, as being new to the committee, I just I had kind of one of those experiences I've had a couple times in this committee where I read through the question, I have an initial reaction, I read more deeply the rules, the comments, other states and their interpretation of things, and it gets me thinking. So let me just start with the CLE piece, just so that I'm understanding it properly. So I practice in secure transaction negotiable instruments. I do a bunch of CLE stuff. My area of practice is so boring. There's never going to be a case that's like been in the press, right? That's okay. Strike that, Your Honor. Had a couple, but generally speaking, I've never had a problem talking about my cases hypothetically. And of course, there's a carved out exception for discussing things hypothetically. But I contrast that with what my neighbor here is Eddie Spees. I don't know if you guys know Eddie. He's with the AG's office for a long time. Anyway, I can remember one of my first experiences as a young lawyer in North Carolina was going to a CLE over at the Bar Center where Eddie Spees was dissecting in great specificity one of his cases. And I learned a heck of a lot about civil procedure and thinking through the problem by listening to Mr. Spees dissect a case, and it was wonderful. It was I learned a lot, and it was like one of those all day things, and so I guess what I'm trying to make sure I understand on the CLE piece is, as someone who does a lot of CLEs but never has a real problem talking within a hypothetical context, so that was my initial reaction. Then I thought about the Eddie Spees case and how much I learned by him doing that. So I guess my first question is, just so that I understand the premise of the CLE question, we're only talking about highly publicized cases that cannot be spoken about within a hypothetical context, right?
No, we're not. We're talking about any case that a lawyer has, and it can be spoken about in a hypothetical context as long as the specifics of the hypothetical don't precisely identify the case. Basically, the way that 1.6 is interpreted under Kahn, a lawyer really cannot discuss any aspects of the case publicly in any forum, whether the information is part of a court record, public knowledge, or generally known. A lawyer cannot reveal or disclose information that was obtained during the course of the representation from whatever source. Now, Suzanne, help me on that. Is that fair?
Well, no, I mean, there's an exception for hypotheticals. If you can present at a CLE and discuss your case in a hypothetical, that is perfectly okay. But the issue, I mean, so Jack's point, he can talk about patents or whatever. Nobody's going to know what specific case he's talking about. No, that's fine. Hypotheticals are fine. They were fine before this opinion. They're fine after this opinion. The problem with this inquiry is there was no way for this lawyer to talk about this case in a hypothetical manner because everybody knew the case. If he started talking about the flipping the bird case, everybody knew who it was. So there was no way to present it in a hypothetical. But there's two exceptions to the opinion, to the rule that we have now, and that's hypotheticals or consent. So that's what we do need to keep, those two exceptions in mind. If you're doing a CLE and you have your client's consent, you can talk about whatever you want. If you're doing a CLE and you can present it in a hypothetical manner, you can say whatever you want.
Yeah, and some people get that consent like in the retention agreement, right? Because it also applies to marketing, right? Like you hit it out of the ballpark and get a big win. Technically under 1.6, you can't share that big win unless you have client consent also.
That's true.
Yeah, and I think one of the sticky wickets is going to be, if we do end up changing the rule, is whether it's an affirmative duty on the lawyer to get consent at some point, or whether a lawyer can talk about public information and generally known information without actually getting consent from the client.
Right. And, if I can, I guess I know we're kind of framing the issue and trying to see where exactly we start with this discussion. And, I had just given Abby watch my CLE a couple of weeks ago that I presented to the North Carolina Advocates for Justice on this very topic. And it was on confidentiality. And really I would say one of the inspirations for choosing that topic was not only the comments, which we loved getting. I want to emphasize that to anybody who's watching this on YouTube. I thought it was fantastic seeing the engagement from the bar on this particular issue. But I think as I have talked about this opinion with other lawyers, if we talk about it amongst ourselves, it seems like we all have an idea of what 1.6 is, and that might not be exactly what 1.6 really says. And that was kind of the thing where there is a bit of a disconnect, because 1.6 covers everything. Comment 3 to 1.6 says that it covers all the information, not just a privileged information, not just work product or any other protection that's there. It covers everything acquired during the representation, whatever its source. And that's like a quote from comment 3, whatever its source. So it is all encompassing, it is indefinite. And so we kind of start there. And I was explaining the thought process in that CLE for this opinion that, we have this broad net cast over all the information being encompassed under 1.6 under this duty of confidentiality. And so and I think Abby had shared this with me that during one of their committee meetings, they were discussing this opinion and somebody basically offered the thought, you got to be careful what you ask the bar. Because I feel like when this question was posed to us, we can't give any other answer but the answer that we gave. But looking at the comments, knowing that broad net that we have for 1.6, looking at the comments, I think and I've said this as much in a number of CLEs since the opinion came out, that the opinion I think is correctly decided, but it does create some impracticalities, and it's just not really satisfying as far as our own practice in terms of CLE issues. The question, I think one of the comments, maybe a couple of comments brought up, if you are representing someone, you take a case to the Supreme Court and you are in subsequent representation, different client, but on a similar issue, and you want to say, hey, you know what, in this case, I did X, Y, and Z, and these were some of the considerations, and this is ultimately what we did. Is that covered under 1.6? Because technically it is confidential per 1.6, and that seems very impractical. It seems like it works against the client's interests. It inhibits the lawyer's practice and their ability to give the most effective representation by drawing on past experience. And so I think that's when when we started looking at these other jurisdictions, what do other folks do? If this is really, I guess, kind of a combination of things, if the current, what we consider the correct interpretation of 1.6 produces an impractical result, but the practice, the profession doesn't really look at 1.6 in that same way. The profession has been treating confidential information as truly being the private information, the secret information. And you see what other jurisdictions do to really kind of match the rule and the intent and the protection of certain client interest with what you actually have in the text. I think that might be an opportunity, that there is an opportunity for kind of for all of us to be on the same page, and we may actually already be on the same page. We just need to get the rule on the same page. So I offer that as kind of I guess some framework. And by all means, if anybody wants to see my presentation on 1.6, the deep dive into confidentiality, I based it on the pop culture themes of the movie Fight Club. So that's I don't know if we really want to take that left turn here, but I'll just offer those thoughts as we start this conversation. I think this is a worthy consideration, but it is something that I think we need to proceed very cautiously, because 1.6 really represents one of the core, if not one of the most important duties to our roles as lawyers. So I see Abby has, I see some stuff in the chat. Abby, do you have a thought that maybe you'd want to share, if that's all right, Eben?
Oh, yeah, sure.
Yeah, if that's acceptable with the group. I really do appreciate the time to be here today. Of course, NCAJ is a robust CLE program, so our members are very concerned about how they can provide what they think are very valuable CLEs if there's some constraints. I will tell you, one of the other issues that came up, and it came up after Brian did the CLE presentation, is the question of sharing documents. If you have filings that pertain to your case and somebody asks for similar filing documents, are you allowed to share those without the client's consent? And so it does potentially go a little bit broader than CLE. It potentially goes to how you, how any association, whether it's NCAJ, the ADAs, CADAs, or the bar, if you have this collegial environment where you try to support your colleagues and you're sharing documents, is that going to be a violation? And so just to add that to the discussion.
Todd has his hand up.
Oh, sorry.
Yeah, I see Todd has his hand up.
Yes, thanks. I have a couple of questions, being new to the subcommittee, obviously. The first is for, and ignore my phone, I'm trying to let it stop ringing, my cell phone. One question I had was to Suzanne, is there any impediment to getting consent in the retention letter?
You know,
And
I'm
that's the
not sure
question.
about that because it has to be informed consent. So I would have to look at that a little bit more closely because I'm not sure, depending on how specific the retainer agreement was. I would think maybe if you said you consent to me speaking about this at CLEs or podcasts, that'd probably be okay. I'd have to look at that a little bit further, but the
Yeah.
issue would be whether it was sufficiently informed.
Yeah, and that's the question I had.
That
Go
was
ahead.
brought up
Go ahead, Evan.
that was brought up in some of the comments about there was no guidance on
Right.
what consent was and how to get it and what informed consent is.
Okay, maybe we could
Mark?
add a maybe we could add a new comment or something to that effect. The other question I had is where if we were to go down this road, I guess we already are. Looking at the opinion and I guess the other opinions from other jurisdictions, it seems like we're sort of following the ABA and lots of other jurisdictions, and Virginia being carved out on the constitutional grounds. Are there other jurisdictions in addition to what's listed here that go in the opposite direction, that say this is not okay?
Not that I know of.
Okay.
Yeah, I think we looked at that. There's 12 jurisdictions that have modified some part of 1.6, but these are the only ones we could find. The ones with the original subcommittee, the only ones that we could find interpreted the present language of 1.6 consistent with the Khan opinion. So, and Mark, you got your hand up?
Thanks, Evan. And I wasn't part of the original discussion, so this is great background for me to understand some of it. And I do think it's a tricky issue. One thing I was thinking about that you may have already covered, but I wanted to make sure I understood is, addressing whether there is implied consent that would result, I think, where the client specifically says no, in an opinion similar to what you have, but might be different if you haven't heard from the client. Obviously, we get implied consent all the time when we're filing something with the court. We're assuming that information the client gave us is now something we're going to share with the court in connection with the motion, in connection with presentation of evidence. I don't know if it seems to me potentially reasonable to assume some kind of implied consent once information is available and out in the public. In other words, if you've shared it with the whole world by posting it on filing it with a public website, is it really reasonable to assume that the client's going to object to you sharing it with everyone if you then share it with a group of 30 people attending a CLE? So that idea of expanding complied consent to extend to publicly filed information seems plausible to me, but I don't know if you've exhausted that. But I just wanted to have a little discussion around that option before we move forward. I see a number of responses. I see Jack and Suzanne and whoever else.
Well, I think Todd was first and then Suzanne.
I think Todd's got his hand up, but Suzanne, go ahead.
I was just going to say the rule says that it's unless you have implied authorization in order to carry out the representation. So, I mean, it's specifically limited to something that you're doing that's in furtherance of the representation and on the client's behalf is what Rule 1.6. So that would not be speaking in my opinion, speaking at CLEs. It's what you're talking about seems like some sort of a waiver, which there's no provision for a waiver in 1.6. There is implied authorization, which is an important exception, but that is specifically related to something that you're doing to carry out the purpose of the representation on behalf of the client.
Yeah, and I'll say, Mark, when we had the original inquiry, I remember Suzanne and I talking about that and saying, is this an implied consent thing? It just, like you said, it sounds reasonable. But it's that, again, the language of 1.6 and to carry out the representation. In order to carry out the representation, we couldn't really, I think, honestly say that Mr. Khan doing a podcast about this was for the purpose of carrying out the representation. So we didn't feel comfortable saying, yes, you have implied consent. And I think it's a great point that strikes at the reasonableness of what we're talking about, but that the rule the language of the rule forces a different answer. And I think that's where it kind of, like you said, it's a tricky issue. That's where we are.
And Ellen, you got your hand up.
Yeah, I have two comments. One, I would just add to the CLE conversation, legal education, because while it may seem a smaller amount, right? It's having guest speakers in my class, having someone who was on a certain side of Nifong's case is a very important piece of my professional responsibility class. And that would be an impossible hypothetical situation. The second thing I would say is I'm a little concerned about the advance consent in a retainer agreement for two reasons. One, the way those are interpreted for purposes of conflicts has been quite narrow. And so I could see that being translated into informed. To Suzanne's point, it's all about how informed it is, right? Can you do a podcast? Well, can you do a North Carolina Advocates for Justice podcast? Or can you do the Serial podcast, which is nationally, right? So I think there's some real distinctions there that would have to be taken into account in making sure that consent was informed. And the third comment I would just say is I hope when we're using, myself included, this is when I started this, and I'm new to the committee too, like Todd, I was thinking of generally known in public as the same, but they're not. And there's ways we can make distinctions based on that could be helpful.
I had one comment. One more question I meant to ask earlier. Did you guys look at whether or not any other jurisdictions have different titles to this rule? For example, there seems to be a disconnect to me between the title confidentiality of information and the text, which basically talks about a general prohibition for the most part of any information, not just confidential information. Any ABA opinions or jurisdictions address whether or not the rule should be named non-disclosure of information as opposed to confidentiality? I looked at one of the comments and somebody said the title of the rule talks about confidential information, and even the text does, but it seems to me the language is obviously broader than just confidential information. Anybody address that anywhere?
Suzanne can.
No, well, I was just going to say, I saw that comment too, and I thought, let me go back and look at this, because if the title was confidential information, then I think that term confidential would carry through the rest of the rule, but it's not. It's confidentiality of information.
Right.
Then the rule goes on to talk about what information is confidential. So the title, I think, is accurate. Confidentiality of certain information that is set out in the rule. If the title was just confidential information, then I think that you would read the term confidential into each section, which is something we're considering doing when we're editing the rule.
Well, the definition section refers it back to 1.6, to the definition of confidential. Jack, you got your hand up?
Yeah, I did. So just real quick, yeah, I agree. I think that's right. I noticed a number of people seem to misunderstand that the title is saying not confidential information. It says confidentiality of information, not pertaining simply to confidential information. And I think that's important because I want to piggyback on something Ellen said and Mark said, combining, kind of coupling the advanced consent concept and the document confidentiality. Okay, so I'm teaching a CLE on negotiable instruments. Oftentimes, I use actual documents that I redact as examples so that I can go through a hypothetical with whomever I'm teaching, okay? Now, I think we have to be very careful here because if a document is attached to a pleading, and in some of my cases, like some of y'all's cases as well, there are bajillions of documents that are attached to pleadings over the course of an 18-month lawsuit. Well, because they're attached to pleadings, aren't they part of the public record? Now, that doesn't give me, in my opinion, authority to just start using these documents in the CLEs I'm teaching without redacting them, although that is now public information because it's come into the courts through exhibits to pleadings. And I think that that's very dangerous. I think that's very dangerous. You think about the level of specificity of some of the documents that are now quote unquote public information and public data. When the comment that Ella made about advanced consent, what would my advanced consent have to do? I can't just generically say, hey, you give me the ability ad libitum to talk about anything I want involved in this case, without the client understanding that that would include some hyper sensitive information that they might not want me sharing that was in those documents. So I guess what I'm saying is just that taking into account the fact that the language of 1.6 is really our obligation to be confidential with information is vastly different than the interpretation of some of the people who wrote in saying that this is only applicable to confidential information. And as someone who utilizes exhibits that are public in that they have at one point been attached to pleadings as exhibits, in my CLEs, I always would redact them. I would never presume that just because that was now public information that I'm free to bandy about that information. I just think that's something that I would be very careful about using here.
All right, Bobby Joe.
Hi guys, thank you so much. And I apologize for not submitting a written comment. But I just wanted to say that I really think that the committee got the opinion correct. I would not advocate for a change in the rule back to the model rule version, where many of those jurisdictions that are further defining a confidence or a secret, they're using the model code language back, to the 1968 version. And I do think that there's certain things that need to be tweaked, perhaps the questions about documents, perhaps some clarification about legal education or what you can say in court. I also think that it would be helpful to have better clarity about North Carolina's phrase of acquired during, and then how comment 1 talks about information relating to. I've never quite understood how to teach that. But in teaching law for over 20 years, I thought that teaching confidentiality is one of the hardest things to do. And about 10 years ago, I stumbled across something that made it easier for me to teach confidentiality to law students. And I started saying there's a lot of different theories about how you could teach confidentiality, and talking about the principal agent relationship, the fiduciary nature, trust, talked about the instrumental value of confidentiality, that the more information you get, the better you can represent the client. And none of that worked. Students on the final exams, they still could not grasp the scope of what information relating to the representation included. And so finally, with kind of our information age and social media, I went with a property analogy. And I would start saying to students early on that this is not your story to tell. This is not your story to tell. And I actually give this example. I say, you're at a party, you're at a CLE event, whatever. Everybody's talking about it. Everybody knows. Guess what? You're the only person in the world who can't speak about it.
Right.
And there's a value in that. That I know that my lawyer will not talk about my story. And that if I don't have a lawyer, I'm worse off, right? And so in order for me to get a better outcome in court, I have to hire a lawyer, because I don't know how to navigate a court system, and I don't know how to do legal research. And so, it puts somebody in a catch-22. And so this kind of autonomy, this value of client sovereignty is critical. And the fact that I'm the only one in the world who my client can count on for not telling their story and not gossiping, even though it was at the Supreme Court, it was in, it was above the line, above the fold at the NNO. It was, plastered all over social media apps, but they can count on me. It is not my story to tell. So I tell my students, I say, so when you tell your client's story and you don't have their permission, you are stealing from your client. It's property. You're stealing from them. And I got an email from a student this semester after class Professor Boyd, I just wanted to let you know that I had an aha moment in class today, and it was all thanks to you. Your property analogy regarding the client's story and the importance in a lawyer's stewardship of that story was something that just clicked for me. I am very visual and I love concrete imagery. To make the information shared by a client tangible and touchable by comparing it to property was just such a great learning point for me. And of course, I immediately emailed the student and said, do I have your permission to share this excerpt from your email? Because this is his story. And I've done, beyond law, I've done a lot of workshops in storytelling. And in the storytelling world with folktales, there's a lot of oral tradition. And so, and there are, there's etiquette there that you don't tell somebody else's version of a folktale without their permission. And the folktale could be Jack and the Beanstalk, right? Or any other Jack tale. But when a storyteller tells that story, their version, it's not like it's written down, it's just oral. But again, it's not your story to tell without the permission. The comments that I read, they were hard for me to get through. I had 2 different sessions, and they were hard for a number of reasons. The first time I read through the comments, I was like, where's the client? It was all about me, and my, ability to present a continuing education event, so that was hard. The comments were also, some of parts of the comments were difficult because it was clear that many attorneys didn't understand the rule. They just didn't understand the terms, the rule, what it meant. That another part of the comments that were difficult is they didn't understand the proposed opinion either. So many folks talking about how they wouldn't be able to use a hypothetical. And so there was part of the commentary too, or parts of the comments that talked about the burden. And I'm not too sure that I agreed with that how burdensome it would be. That there are so many creative ways that we can do things, that we can have other folks present that portion of the CLE, somebody else, who didn't have the case, or we could just get client consent, or we could, it's not that burdensome to redact. And that there are so many cases to teach from. On the other hand, I have been in presentations and learned a lot. And I'm thinking, I see that Attorney Willoughby will remember the In re Death of Eric Miller case, and in some cases, it's hard to get informed consent. The client's dead, right? You're never going to get that. And so I am trying to be as open as possible. And I just want to say that I think you guys have done a great job. I think that, again, it's a hard concept to teach, but I think it reflects on our profession and how people view attorneys and the image of the legal profession. If we can't be somebody who our clients count on us to not tell their story.
Yeah, I think I'll get to you in a second, Mark. Thank you, Bobby Joe. I think that on the ethics committee, we keep coming back to confidentiality as the bedrock of the rules of professional conduct. That is singular in its importance, and I think your analogy is good, and is one that Amy and Bill brought up when we first talked. It's the client's information to share, not the lawyer's. So, Mark, you had your hand up.
That was from before. I think I'm good. I'm good, Evan.
Okay. All right. Anybody? Any further discussion on the comments at all? When I read through them a second time, Bobby Joe, I listed 20 different buckets that it was in, but by and large, there's a misunderstanding of Rule 1.6 that was seemed to be prevalent in most of the comments. So, Bobby Joe, let me ask you, Bob, just to distill what you're saying that you think there's a way to save 1.6, but with a little bit of a carve out or some further explanations. or are you advocating that we keep 1.6 as 1.6 and leave it as it is with NRACON as it is?
I value leaving the rule as it is. I do think that the title to the rule creates confusion. Also, I think that the history of the rule creates confusion, that the fact that a confidence under the model code was defined as anything that's protected by the attorney-client privilege. And then the fact that they're using confidentiality, you know, like, I mean, that's just hard to grasp how those words are used. So for example, I never talk about those things. I say, this is our unit on like, that's all I can say, because you can't say secret because that's a term of art. You can't say confidence, that's a term of art. Students have a hard time grasping things like generally known versus public information, you know, the fact that those are not the same thing. I like the rule as is.
Yeah, we do live in a different, we do live in a different world circa 2021 with social media, with websites, with brag boards, with all kinds of ways that lawyers get information out to clients and also to the public. And there is value, I think, in being able to discuss cases both formally at CLEs and informally with other lawyers about specific cases. I know that I spent 10 years in the Carillon building where the U.S. Attorney's Office is now. And for years, there would be a group of us that would meet downstairs after work, U.S. attorneys and a couple of defense attorneys, and sometimes federal judges would wander over. And that table became a seminar for all of us, week in and week out, because we discussed cases and we discussed, the law, and we discussed procedures, and we discussed specifics. And it was incredibly valuable for me in my practice to listen and learn, and also to share from our perspective, from a defense attorney's perspective, what we do on generally on the other side of the curtain. So I think there's value in recognizing that the world has changed, and recognizing there's value in formal and informal discussions of cases, as long as it doesn't stray into privileged and confidential or secret information. That's as chairman, I guess I'm supposed to not have an opinion and get people talking, but I think there's value in that. So I'm leaning towards suggesting that we look into modifying Rule 1.6, which is also going to stretch into modifications of 1.9 and 1.18 and the definitions section and the comments. I mean, we're really going to have to scrub the rules to make them, and comments to make them consistent. It's a heavy lift if we do that. Discussion? Amy? Help us here.
I love that you were willing to pull me in. So can I just reveal that? So I do some teaching too, and I teach the ABA rules, and then I teach the DC rules. DC is one of the states that does this slightly different, right? And so I'm teaching it right now, so it's really stuck in my head. And they have confidences and secrets, right? And define those different. And like Suzanne's chart, you guys probably remember, had DC as one of the ones that does it slightly different. So I don't want to drag us down in too far, but it's something for us to consider, that the way they define secret in some ways is the way we would define confidential, right? I think. Do you want to go that direction? Talk about that kind of stuff, or do we want to just move into are we talking about whether or not to amend the rule or not? I just don't want to get too far ahead.
Well, I think that's where we are. On the agenda, we're down to 3B.
Yeah.
I think reviewing 1.6 and what our rule says, and the scope, and what other jurisdictions say. So
good.
I think that's where we are.
Yeah, I'll just read, it defines secret as refers to other information gained in the professional relationship that the client has requested be held inviolate, or disclosure of which would be embarrassing or would be likely detrimental to the client. And so it's a different scope than, it's not quite as broad as the ABA, right?
Right. It seems like that would also give the client the power to basically put a gag order on the attorney and say that any information that you've obtained in the course of representation, I consider confidential and secret. So,
right. I mean, and there is this aspect too about like when my lawyer says something about the case, even if it's public, that's different than the talking head or a different lawyer saying that. And so a client could say, yeah, you won in the Supreme Court or you lost in the Supreme Court, right? Can go either way in our, the way that we, do a lot of stuff and say, for example, litigation, and me saying something about that win or loss is different than my colleague or another attorney saying that. And my client should have every right to say, you don't get to say anything. You don't get to write the book. You don't get to go to the CLA has always been my view. And the DC rule allows for that. But it does put some pressure on the client to be the one to do that. It's not automatic, if that makes sense.
yeah, I was kind of liking the New York rule as well and the definitions that they had. It gave it some clarity and some definitions and guidance, I think. But
I agree, Eben, and I like the way in, excuse me, with the New York rule, I believe they not only say in 1.6, this is confidential, but they make very clear this is not confidential.
Right. Yeah, I love the definitions in that rule. Yeah, what is and what isn't.
That's right.
Yep. Judge Pittman, you got anything to weigh in on this? I really wonder, what your perspective is from the bench side. You need to unmute yourself, Bill.
If we had sent out a video of Professor Boyd's explanation with asking for comments, we might have had a different set. That would have been helpful. I agree with you, Anthony. We somehow or other just need to fix it to reflect the reality of it, but I think we ought to also keep in mind what Bobby Joe said, in that, it ultimately still belongs to the client.
Right.
Even if it's public.
Suzanne, you want to add anything to the discussion at this point?
No, I just want to make sure that everybody sort of agrees that there's nothing that we can do to the opinion. There's no way to get the results that the bar is asking for without changing the rule.
I think there's consensus on that. Yeah, Jack, go ahead.
No, I was just going to say, being new to this subcommittee, just for my dull brain here, Suzanne. So when you say that the bar is asking for, you mean all the comments,
right?
All the people. Okay, just
yes.
Right. So and then am I understanding kind of the way we're framing this thing moving forward is the opinion as it's crafted now, we agree is consistent with 1.6. That's not the issue. The issue is whether or not 1.6 itself is what we think reflects the ethical standards and mores moving forward. But my question would be then, what would that mean as far as the opinion itself goes? For example, one of the things I have not brought up is, I'm probably remiss in not having brought up my boss's letter that was in the packet, and George Housen's concern about the problems that we specifically have at Legal Aid, where we're required to present data and information to Congress and Legal Services Corporation on what we're doing. That's how we get funded. We can show them how we're properly spending their money. And to do that, we need to reveal certain public information about the cases we're handling so that they know we're using their money properly.
I think that's a different issue. I think that might.
I agree. I
absolutely
agree. And so that's why I was hoping that would be, Suzanne, that would be put aside in the sense, but I just wanted to clarify that as far as this opinion goes, are we saying that this opinion would not be published until after we wrestle with the rule itself?
There probably wouldn't be an opinion. There would just be.
There probably wouldn't be. Yes. Okay. Thank you. And that's just the clarification I wanted. That way, later this afternoon, when George calls me and says, "The hell's going on?" I can say that as things stand right now, because it's our opinion that as things stand right now, we are being ethical. That the 300 lawyers, the way we operate, is ethical, and we're sticking by that. Darn it. And as long as there's nothing that's going to be happening or published in the meantime, that's perfect. Thank you.
Well, as we said in the big ethics committee meeting, these rules are rules of reason at this point, and there's nothing that prohibits you and legal aid from doing what you're doing. And really, there's not an opinion that actually would, I think, stop some CLE presentations at this point because they're rules of reason. But I had a separate bucket of your legal aid issues on my list of 20 because that is unique to you and your organization. So, and same with the workers' comp people. But so I guess I'll ask again: is it consensus of the subcommittee? Hang on, Colin. Consensus of the sub. Okay, go ahead, Colin.
Yeah, I thought Professor Boyd's issue about the acquired during the professional relationship is really a key to what ought to be the reasonable expectation of a client. And it seems like, information that comes out in a public hearing and arguments before the Supreme Court or in the publicly attended trial seems to be in a completely different space. And I just think that that's probably a good place for focus is how you acquire the information and what the reasonable expectation of the client would be. Certainly, if you do an independent investigation, that ought to be the client's. But if you hear testimony from the witness stand or you hear the government take a position in their oral argument in an appellate court, that really shouldn't be an expectation that you couldn't discuss that issue, I don't think.
So Colin, are you suggesting that then we wouldn't need a rule change? That's just what I'm trying to make sure that everybody that's on this call.
I don't know.
Is there a way to do this without changing the rule? Did anybody see anything in the comments that showed a way to protect CLEs, legal education, legal aid without changing the rule? A different interpretation of the rule as it's written.
Well, one of the comments pointed out that a client does not have an expectation of privacy to information that is either part of the public record or generally known. So they grounded their comment on reasonable expectation of privacy. And I don't buy that because I agree if 1.6 as it stands right now, it's the client's story, as Bobby Joe said, and nobody else's as it sits right now.
Mr. Chair.
Yes, sir, Todd. Yeah, go ahead.
I have no concerns about the way the proposed opinion is written. I think we have it right based on the existing rule. In terms of comments about whether we should consider amending, I do consider I believe that the first sentence of the rule and the first sentence of Section D, which talks about confidentiality, and then the title, or in a bit of attention. I read confidentiality a little differently than I read any information disclosed during the course of the relationship, any information acquired during the course of the relationship. So maybe we can look at tweaking that if possible. And the other question I had about amending it at all is, are we talking about amending this rule because of this one inquiry we have gotten here, or because we have gotten a multitude of inquiries from lawyers such that we need to amend it because it's becoming such a chronic problem?
Brian, you want to take that one?
Yeah, I would say we have not, to my knowledge, received a great deal of ethics inquiries, nor have we received a great deal of grievance complaints about folks
1.6.
talking about stuff that should be considered confidential under the rule. I think this is really, this conversation is really, I guess that this inquiry, this opinion has been the catalyst for this conversation. The thing that I think just warrants at the very least this discussion about amending the rule is that in looking at this issue, it's while they're not ethics inquiries, I feel like there are comments, just a bevy of comments, whether they're in individual conversations or at the committee meeting themselves, where there seems to be kind of a disconnect between our understanding of what Rule 1.6 actually covers and what it really does cover. And that's the part that I think is worth looking at. But yeah, we don't have a lot of folks that are speaking up on this. And to your point, I know you said this earlier, Evan, the rules are rules of reason. And so it's not something that that I think, as far as what could result in, is there going to be a litany of complaints, disciplinary complaints, because someone has presented at the CLE? No, I think that would be something that the state bar, and I don't want to speak for the council, I don't want to speak for the DHC or anything like that, but I do think that people look at this as rules of reason. And that's where we go into, and I guess I wanted to bring this up, the Virginia Supreme Court, their analysis, and whether or not, we talk about the interests that are being protected. It's the client's interest of their information. And the Supreme Court in Virginia essentially determined or concluded that those interests weren't really served in restricting a lawyer's ability to talk about information that is in the public record. That essentially, once it's in the public record, I know there's kind of maybe there's, at the very least, we could call it a joint ownership between the client's information, but also the public's information. And the Virginia Supreme Court kind of looked at the restriction, which 1.6 is a restriction on a lawyer's freedom of speech. And that is something that I don't have any real constitutional concerns with that. I think there is a significant reason for that restriction. But that the Virginia Supreme Court found that essentially that restriction was in light of this category of information about the client that has been entered into the public record, that the interest from a lawyer, from a freedom of speech, First Amendment perspective, outweighed the interest of a client in prohibiting that one person from talking about that which everyone else is allowed to talk about. And I don't know if that offers any, I guess, just additional thought in this conversation. If when we're looking at a definition, is public information, broad though that may be, is that a category that we want to consider in terms of a definition of what is covered by this rule? So I don't know. I don't want to sit here and sound like I fully endorse the Virginia Supreme Court's analysis and think that they hit it, right on the head. But I think they offered a good argument that's worth considering. And I guess I want to throw that out to everybody. But to your point, again, to your question, Todd, no, we haven't had a whole bunch of things. I just think this kind of has presented an opportunity to recognize that we may all be thinking one thing when the rules say something else.
Ryan, did you say what case that was out of Virginia and I missed it? I'm sorry.
It was, oh goodness, it's in our materials.
It's cited in the opinion as well.
Yeah, Hunter, I believe it's Hunter versus the Virginia State Bar.
I thought it was Hunter, but I just want to make sure we were all talking about the same one. That's
yes. It's like 2013.
He had like a criminal case. He had a blog also. Yeah.
Yeah, but Brian, at our first subcommittee meeting where Suzanne, Amy, and Bill and I discussed this, we briefly talked about the First Amendment issue and agreed that it would be taken off of the discussion. But we surmised that down the road, there may be a First Amendment litigation brought against the state bar by a lawyer that wants to put something on her podcast or website. So, I mean, that's certainly foreseeable that litigation is in the offing.
Okay, thank you.
So let me see if we've got consensus here. The consensus is there consensus of the subcommittee that we head towards reworking the language of 1.6 and related rules to come into line with some of the other jurisdictions like Washington and New York? Is that consensus, or is there a motion and we vote? We got consensus, I think. Yep, Bill, Jack, Amy, Ellen.
Yes.
Okay, great. All right, well, so I guess we move on to where do we go from here? Do we task Suzanne with trying to pull together the best of the 12 jurisdictions and put the best of each into a proposed modification? Is that the next step, Suzanne?
Go ahead, Brian.
No, I was just going to say, recognizing what time it is, I don't know if it seems like this may be a good breaking point. And what we could do, Suzanne and I could essentially try to, we've got one proposal in your materials, which is really based upon the New York version of 1.6. But in light of the conversation today, I'm wondering if if maybe it would be better to come up with maybe a couple of different versions. I think the one thing that I will say, candidly, I'm torn on going back to the confidences and secrets version that we see in DC. I think New York's definition, or just New York's approach, may be a little more palatable and clear in terms of offering guidance. But exactly what that definition really needs to be, is it just a copy of New York's, or is it something perhaps a little different? And again, just offering different options may be a helpful thing for our discussion. So I think I'd recommend that, since we're at this point, maybe staff gets together, we try to draft a couple of different options, and we schedule another subcommittee. I don't know that we're going to necessarily resolve it today. So we may not need to keep everybody on the call to push through.
Yeah, and I think we're going to have to sort of cast a net out to see what the domino effect is on definitions, comments, and other rules, and bring everything into consistency.
Right.
Okay. I agree, Brian and Suzanne. That's anybody got anything else to say? Otherwise, we'll adjourn.
I think that's a reasonable approach, and thank you for moving us along.
Yeah, thank you.
All right, everybody.
Thanks,
Stay healthy, get vaccinated. I've got my first shot and getting my second shot in 2 weeks. So yay.